Just when you thought it was safe to come back to the courses, now we have a class video. But we had to cancel last Thursday's class, and that's when we were supposed to talk about USB Carolene products. We didn't think you should entirely miss our discussion of that case. It's a case that invented differential standards of review, suspect classes, and sent economic liberties to the back of the constitutional bus. So we didn't want you to miss it. And to put this transition into perspective, I want to go back for a minute to the Lochner case, which we discussed a couple of weeks ago. That case was decided in 1905, right at the beginning of the 20th century. And it's probably most famous for Justice Holmes' snarky comment that the 14th Amendment did not enact Mr. Herbert Spencer's social status. I think the majority in Lochner would have agreed with that, but they might have responded that the Constitution did include a presumption in favor of economic liberty, and that is what they were recognizing in Lochner. And that's a theme that runs through the cases that come after when things begin to change. One of the interesting things about this is their view of the constitutional presumption prevails for another 2 decades. And it's not until the 1930s that the zeitgeist really begins to shift. And then in 1933, in a case called Nebbia v. New York, for some reason, New York was heavily represented in a lot of these early cases. But in that case, Nebbia, who is a shopkeeper, is convicted for selling a quart of milk at a price below what the Milk Control Board has mandated. So the statute basically allows the state to set the price of milk. And in upholding that statute, Justice Owen Roberts says, well, neither property rights nor contract rights are absolute. And the reason they're not absolute is that the public has the right to regulate in its own interest, and that right is equally fundamental. So Justice McReynolds, who is now writing in dissent, says, if in fact liberty and property can be struck down just because of any difficult exigent circumstances, then we have to be prepared to see every right yield to the impatient voice of the majority whenever there are difficult circumstances. And interestingly enough, the next case that calls forth that kind of response is a case called West Coast Hotel v. Parrish, where, again, Justice Roberts writes to uphold a minimum wage for women. And Justice Sutherland, dissenting in that case, says, freedom of contract was the general rule and restraint was the exception. And the power to abridge that freedom could only be justified by exceptional circumstances. So in other words, the comment that the conservatives are making is we now find ourselves in a situation where the presumption that they operated under has been completely reversed. After West Coast Hotel, the court begins to apply a deferential standard of review that rejects any presumption in favor of economic liberty and instead presumes the constitutionality of any economic regulation. So that sets the stage for USB Carolene products, which makes this shift explicit. And Carolene products is yet another case that involves milk regulation. I don't know why this was so popular in the 1930s, but that case involved something called the Fill Milk Act. And it prohibited the shipment in interstate commerce of skimmed milk compounded with any fat or oil other than milk fat. My guess is that this was a product which was cheaper than milk, and therefore the milk lobby did not want to deal with the competition. So they prevailed upon the legislature to declare such products adulterated and to prohibit their shipment in interstate commerce. The case invoked both the Commerce Clause and the Fifth Amendment, first saying that this exceeded Congress's power under the Commerce Clause and that it constituted a taking. And the court gave this short shrift. They didn't pay any attention to this argument at all. And in fact, the court ended up saying, even if the legislature could present evidence of the rationale for their action and show that there was a rational basis for it, there was no need for it. And the language that's used here is basically, we don't need to rely on the existence of facts which support the legislative judgment. It says facts supporting that judgment are to be presumed for regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless there are some extraordinary facts which would preclude the assumption that the statute rests on a rational basis. In other words, the legislature doesn't have to even justify what it's doing if the court can think of a rational basis for the legislation. That's quite good enough. So what Carolene Products does is to simply demote economic liberties and say, it only requires a rational basis review, and that's very minimal. On the other hand, right after that statement, there is footnote 4. And footnote 4 has been characterized as probably the most famous footnote in US constitutional history. And it may well be. It's a very lengthy footnote. I'll just read a little bit of it for you. Justice Stone, who wrote this opinion, adds after saying, we're only going to give this very lightweight review to economic regulation, says there may be a narrower scope for operation of the presumption of constitutionality when legislation appears on its face to be within a specific prohibition of the Constitution, such as the first 10 amendments or what's incorporated and embraced in the 14th. He says it is unnecessary now to consider whether legislation which restricts the political processes that would ordinarily be expected to repeal undesirable legislation is to be subjected to more exacting scrutiny. And finally, he says, nor need we inquire whether similar considerations enter into the review of statutes directed at particular religious or national or racial minorities whose prejudice, whether prejudice against discrete and insular minorities may be a special condition which would require more searching judicial inquiry. So you can read the whole of that footnote at your leisure. But basically, what he's saying is, on the one hand, if it is merely economic regulation, it's only entitled to rational basis review. On the other hand, if a statute involves political rights or discrete and insular minorities, then more searching scrutiny may be involved and may be appropriate. And that dichotomy, this idea that the court will look searchingly, apply strict scrutiny to personal and political rights, and that review of economic regulation will be almost non-existent, is still the way that the court operates today. There is has been no reconsideration, really, of that division that was set up way back in 1938. So that's a quick and dirty review of Carolene products. I never get that right. I think that's probably enough to get us into the discussion of whether natural law, which was, of course, the basis of the presumption that the Lochner court thought it was applying, whether that is appropriately used as a metric in judicial review.